When New York ratified, North Carolina and Rhode Island were the only holdouts. Each had to come to its own decision whether to remain aloof from the Union or to join. As with all the other later states, in the North Carolina Convention, the powers of the federal government was a highly debated topic.
The general government cannot intermeddle with the internal affairs of the state governments. They are in no danger from it. It has been urged that it has a tendency to a consolidation. On the contrary, it appears that the state legislatures must exist in full force, otherwise the general government cannot exist itself.
Once again, we see the fear of a consolidated government. And we see the assurance by advocates that this is not a consolidated government because the federal government cannot intermeddle with the internal affairs of a state. In other words, the limitations on the federal government are what makes it safe to ratify this Constitution. To ratify the Constitution and then discard those limits, and you will have an unsafe Constitution that violates the conditions on which the power was delegated to begin with.
If there were any seeds in this Constitution which might, one day, produce a consolidation, it would, sir, with me, be an insuperable objection. I am so perfectly convinced that so extensive a country as this can never be managed by one consolidated government. The state governments can put a veto, at any time, on the general government, by ceasing to continue the executive power.
Here we see an advocate of ratification hinting at nullification, a refusal by the states to execute a law that they feel is unconstitutional. This is not a consolidated government. States will not enforce unconstitutional laws.
Has any man said that the Congress can deviate from this Constitution? The Congress is to be guided by the Constitution. They cannot travel beyond its bounds.
Here McLean is simply saying that the federal government cannot exceed the powers that are delegated to it.
If the Congress make laws inconsistent with the Constitution, independent judges will not uphold them, nor will the people obey them. A universal resistance will ensue. In some countries, the arbitrary disposition of rulers may enable them to overturn the liberties of the people. But in a country like this, where every man is his own master, and where almost every man is a freeholder, and has the right of election, the violations of the Constitution will not be passively.
John Steele is here saying that resistance is to be expected from freemen. Freeholders will resist, but only so long as they are told what the Constitution actually says and what the founders actually delegated to the federal government.
The officers are only to be sworn to support the Constitution, and therefore will only be bound by their oath so far as it shall be strictly pursued. No officer will be bound by his oath to support any act that would violate the principles of the Constitution.
McLean here is anticipating the Kentucky resolutions of 1798. He says that federal officers have a duty to prevent a violation of the Constitution.
It would be very extraordinary to have a Bill of Rights, because the powers of Congress are expressly defined. The powers of Congress are limited and enumerated. We say we have given them those powers, but we do not say we have given them more. We retain all those rights which we have not given away to the general government. If they can assume powers not enumerated, there was no occasion for enumerating any powers.
Here McLean is pointing out the obvious question. If Congress can do anything it thinks is necessary and proper, then what was the point of listing out federal powers at all? Why did they not just say Congress can do anything it feels is necessary and proper? The answer is obviously that such a constitution would not have been ratified.
A Bill of Rights may be necessary in a monarchical government, whose powers are undefined. Were we in the situation of a monarchical country? No, sir. Every right could not be enumerated, and the omitted rights would be sacrificed, if security arose from an enumeration. The Congress cannot assume any other powers than those expressly given them. without a palpable violation of the Constitution.
Opponents had complained about a lack of a Bill of Rights. In North Carolina, as in other states, advocates said that a Bill of Rights was unnecessary because the federal government would only be allowed to exercise the powers that were expressly given to it. It is the restriction on the delegation that makes this Constitution safe to ratify.
A Bill of Rights might operate as a snare rather than a protection. If we had formed a general legislature with undefined powers, a Bill of Rights would not only have been proper, but necessary. And it would have then operated as an exception to the legislative authority in such particulars. It has this effect in respect to some of the American constitutions, where the powers of legislation are general. But where they are powers of a particular nature and expressly defined, as in the case of the Constitution before us, I think, for the reasons I have given, a Bill of Rights is not only unnecessary, but would.
If the federal government violates the Constitution, Iredell here is not just anticipating resistance, he is relying on it to keep the federal government in bounds.
There is not one instance of a power given to the United States, whereby the internal policy or administration of the states is affected. There is no instance that can be pointed out wherein the internal policy of the state can be affected by the judiciary of the United States.
Here, an advocate of ratification assures us that the federal judiciary will never be allowed to interfere with the internal policy of a state. Davy says, in effect, that will never happen. The New York vote was 30 to 27. As with other states that ratified the Constitution late in the overall process and by close votes, advocates of ratification had to convince the skeptics that this Constitution was safe to ratify. They did that, as advocates in other states had done, by assuring the skeptics that the federal government would only be allowed to exercise those powers that were expressly delegated to it, and the federal government could never go beyond those powers. So the Constitution was safe to ratify. The ratification of North Carolina meant that 12 states had ratified the Constitution. In North Carolina, as in other states, advocates of ratification had assured their skeptical compatriots that the federal government would only be allowed to exercise those powers expressly delegated to it, and the states could do anything that was not expressly forbidden to them. So this Constitution was safe to ratify.